Welcome again to the Melling Law YouTube channel. Today we're going to talk about the 4 big estate planning rules you really need to follow in a second marriage. Rule number 1 is get a prenup. Now, a lot of people wonder, well, why would I need a prenup if I'm not planning on divorcing later on? That's a big misconception perpetuated by Hollywood, television. But a prenup or prenuptial agreement is one of the most vital estate planning tools you can have in a second marriage, or third or fourth, depending on how many you have. The big thing there is that, for one, it encourages early planning. And then the biggest advantage there is that it provides room for more estate planning options in the future that might be unavailable if you don't have one in place. It also can ensure that your plan is going to be effective, so we're going to talk about a few of those in a minute. And then there's also a possibility that your prenup might allow you to have certain asset protection advantages, or plan a little bit better for medical expense planning if there are two people coming into the marriage with significantly different asset profiles. Now, those benefits are a lot less pronounced nowadays, because we're having regulations change constantly that foreclose on some of those opportunities. But nonetheless, the prenup remains one of the most important estate planning tools for second marriages. The biggest disadvantage of a prenup is that it needs to be signed before the marriage. So rule number 2 is update your will. And you might wonder, well, are my old estate planning documents effective even though I've gotten married since I updated my documents? And the question is, it depends. Your wills, trusts, any of your other documents, they usually stay effective after your marriage. However, the surviving spouse can void out the will as it applies to them if the will was executed prior to your marriage. So in that case, if they decide to void out the will, if you have children from a prior marriage, your spouse is going to get the first $75,000 of the estate plus 50% of any remaining interest in the estate, which is a pretty big chunk. And so if you've got an estate plan in place that doesn't plan for that, that might not be a good outcome. And if you don't have children from a prior marriage, the spouse can get the entire estate. So, and you might think, well, my spouse will never do that. But the truth is, for one, surviving spouses have every right to nullify those wills executed before the marriage. And third-party caregivers, if your spouse is incapacitated or in long-term care, those conservators or powers of attorney, any kind of agent on their behalf, may or may not be duty-bound to nullify the will on their behalf. So whether or not your spouse would do that, someone else might be forced to do it in their place. This has a simple solution. You need to update your documents after you've been married. Now, rule number 3 is you need to learn about the spousal elective share. Now, in Utah, this is a really big issue, and if you learn about it, it helps you plan for it, whether you like it or not. A lot of people haven't ever heard of it, but it's basically something created by law. It's intended to protect spouses from being disinherited and left impoverished by their deceased spouse for the rest of their life. Essentially, even if you have a will in place, your surviving spouse can elect against the will, and they are entitled to a minimum of 1/3 of your estate if it was not left to them otherwise. And the estate is a very broad term. It's not just the stuff that's left over for probate. This is the total of anything like insurance payouts, retirement accounts, pay on death accounts, and trusts. Any of that that was transferred to other people upon your death, the spouse can even come after that as long as they get that third. And that's a pretty good chunk. And so you kind of wonder, well, is the plan I have in place going to be affected by this statute? And it easily could be. You might think, well, my spouse would never do that either, but the surviving spouse has every right to elect for that share. On top of that, third-party caregivers may be duty-bound to elect for the spousal share. Another thing is that in Medicaid recovery, if you received Medicaid in your final illness, the state Medicaid recovery might even be able to come after that spousal share. So it really it depends on. If your spouse received Medicaid, the state might be able to come after your elective share to be able to repay that. So there's a simple solution to this. Get a prenup in place. The prenup can often foreclose any of those claims. It might not be able to foreclose the state's Medicaid's office claim, depending on how it's set up, but pretty much the spouse or any of those third-party caregivers are going to be barred if you have a proper prenup in place. Another solution, if you don't have a prenup, you can sign a waiver or disclaimer of that share after the marriage, but a lot of times they're not upheld because it's not viewed as a proper contract where you're acting freely because you're in a marriage relationship. There's kind of an implied trust there. And then finally, solution 3 is to seek expert advice. If you work with a professional, you're going to be able to find some plan that's going to work for you, whether there's a trust option or some kind of other contract option. An expert's going to be able to help you tailor your goals to the situation at hand, and maybe be able to get around these rules if they don't really fit for your situation. Then finally, rule number 4 is get expert advice. And a lot of people say, well, I can do my own estate planning. I'm pretty smart. And, for a lot of people that is the case, but especially in second marriage situations, you're talking about a lot of moving pieces here, and an expert deals with that every day. So they'll be able to advise you on your rights, your obligations, and even your options available to you to allow you to achieve these estate planning goals. An expert can help you balance a lot of different goals, providing for spouse's needs versus ensuring your descendants are going to receive what you intend for them. Another issue is you might be worried that your ex-spouse will be controlling the funds you leave for your minor children, and so an estate planner can help you around some of those issues. And then finally, providing for family expenses during estate administration. Sometimes the probate process can take anywhere from a few months to even a year or more, and you want to make sure that your family is going to be able to meet their expenses during that period. If you're going to go through probate, if you've got a trust in place, making sure that that's well funded and that they're going to be able to get by on that. And then finally, as always, you can reach us here at Melling Law. Our phone number is 435-572-0807, and you can reach us anytime by email as well at office@mellinglaw.com.